Before you sign any documents admitting a loved one into a nursing home or assisted care facility, you will want to see this next story. A local man did not realize he had signed away an important right for his sister, but a New Jersey court sided with him, and the decision could set a precedent for anyone signing any type of contract. CBS 2's Alice Gaynor with this exclusive story.
When Mary Klein fell at Emeritus at Emerson Assisted Living years ago, doctors told her brother it appeared that a considerable amount of time had passed before she was found.
They found her in her own blood and feces, and she was totally dehydrated.
The fall put the then 85-year-old in the hospital. From there, she went to Care One at Valley, where Frank McMahon says she got worse.
She contracted C. diff. She contracted a number of sores.
When McMahon decided to sue both facilities for personal injury, he discovered that during the rush to get her into Care One, he quickly initialed a page without guidance, signing away Klein's right to a jury trial, instead pushing any claim they might have to arbitration. No jury and no judge.
It requires a hearing that will be conducted in secret. You also have to pay. The arbitrator is paid.
But last month, a New Jersey appeals court ruled that Mary Klein and her lawyer, Thomas Howard, could take Care One to trial. The New Jersey Appellate Division found that Care One's arbitration clause was unenforceable, and the court found Care One's clause to be a one-way street.
They could remove the case from arbitration at their decision. It was only the resident that was bound by the arbitration clause.
Attorney Craig Hubert is not involved in this case, but represents victims of nursing home neglect and read the opinion. Both Hubert and Klein's attorney agree this decision sets a precedent.
What the decision means is that the courts must look into whether the person who was signing it was given all the information that a reasonable person, somebody like Frank, needed to know in order to realize what rights he was giving up and that he was given the opportunity to say no.
John Dolan runs the nonprofit Healthcare Association of New Jersey. The group suggests a best practice model for the right arbitration agreement.
Include a separate statement in the packet that clearly says what the rights and obligations are.
Mary Klein is now 91 and confined to a wheelchair.
She has lost 5 years of her normal lifestyle.
Bottom line, Frank McMahon says,
make sure you know what you're signing. You're in a stressful situation. Your relative is going into some kind of medical facility, had no idea of the magnitude of that little one sentence.
Frank McMahon took his sister out of Care One and placed her elsewhere. Care One did not respond to calls for comment. Klein has a trial date set for July 18th. Now, as for the court's decision and the wider scope of this ruling could apply beyond nursing homes to other industries. Attorney Craig Hubert, you saw him there in the piece, he explained it to me as, now there's a map for the trial courts. So for people looking to have arbitration clauses thrown out, courts will have to look at factors like, was there a meeting of the minds when the contract was entered? Pressures of the moment when it was signed, the sophistication level of the parties. Does the person signing understand everything? Maurice?
Important story, Alice. Glad you told it tonight. Thanks so much.